Well, welcome everybody, and thanks so much for joining us today. We're really excited to have you here and to have our panelists here to discuss this question of the intersection of transitional justice and the rule of law. Before I introduce our panelists, I want to spend just a few minutes talking about why we at ABA ROLI think this is such a critical issue for discussion at this point. Transitional justice has been defined as the field of activity focused on how societies address legacies of past human rights abuses, mass atrocity, and other forms of severe social trauma. It follows that transitional justice tends to focus on countries who are emerging from periods of repression or of conflict, and in which there's a window of opportunity for a more democratic and peaceful future. The rule of law doesn't limit itself to that moment. It focuses on building the institutions and values that are necessary for the long-term state that we call the rule of law, and that has been defined as a state of affairs in which the state successfully monopolizes the means of violence, and in which most people, most of the time, choose to resolve disputes in a manner consistent with procedurally fair, neutral, and universally applicable rules, and in a manner that respects fundamental human rights. But while the rule of law doesn't limit itself to periods of conflict or post-conflict and repression, I think that the moment that follows those ruptures is often critical to long-term construction of the rule of law. From a practical perspective, as many of us know in the room, it's often that moment when donors are most willing to support long-term institution building and long-term rule of law reform. So that's often the moment at which we see a flurry of rule of law initiatives beginning. At a more conceptual level, I think that it's also fair to say that the moment that follows conflict or repression is the moment of maximum influence for rule of law practitioners. That's often the moment at which old institutions have fallen and can be remade, and it's the point at which the old political elite has perhaps been replaced by a more progressive group of stakeholders. So given that it's perhaps inevitable that transitional justice and the rule of law share the same playing field, and that both try to use that period that follows conflict or repression to pursue their own goals and to create the institutions and values that they both hold central to the work that they do. So given that, we think that it's vital, and it's perhaps a question that, while getting a lot of attention now, hasn't necessarily got attention in the past, and that is, are the goals of these two fields compatible? And in practice, are they in fact complementary? We're very, very lucky today to have three diverse practitioners to discuss those questions with us today, and I'm sure that you all in the audience as well will be able to contribute to that debate. So to my right, we have Elizabeth Betsy Andersen, who is an ABA ROLI board member. She's Executive Director and Executive Vice President of the American Society for International Law. She's also served as the Executive Director of the American Bar Association's Central European and Eurasian Law Initiative. I'm sure most of you have no idea what that is. It's ABA CELI. And she was also Executive Director of Human Rights Watch's Europe and Central Asia Division. We also have Olivier Kambala. He is head of ABA ROLI's Mali office. He is implementing, as we speak, a program on transitional justice in Mali. And he also works on these issues in the DRC, in Guinea, in Togo, in Mauritania, in Burundi, in Tunisia and Namibia. He's worked for the ICTJ and also for the Office of the High Commissioner for Human Rights at the UN. And finally, last but not least, we have Andrew Solomon. He is a transitional justice advisor in USAID's Center of Excellence on Democracy, Human Rights, and Governance. He's also been a director in the Security and Justice practice at Blue Law International, was a foreign policy fellow and deputy director at the Brookings Institution's Project on Internal Displacement, and has worked at ASIL, at ABA CELI, at the OHR in Bosnia, and at the United Nations High Commissioner's Office for Refugees. Yeah. Before I begin, I should say that all three panelists are here in their personal capacity, so please do not attribute anything that they say to their organizations, and particularly in Andrew's case, to USAID or to the United States government. The format that we'll follow today will be question and answers. We'll aim for about 45 minutes of discussion in which I'll pose questions to the panelists, and then we'll have questions from the audience. And I think we'd all also encourage you to give comments on the content of this question, provided, of course, that they are relatively brief. I'd also been instructed to say that those people who are participating online, and hopefully there's a fair number of you, if you do have questions, you can pose them through our online forum, and they will then be put to the panelists in this session. So enough from me. Maybe we can begin. We've just divided this question somewhat into conceptual and practical. So we'll begin at a conceptual level. And I want to do that by quoting United Nations Secretary General Ban Ki-moon, who I'll ask our panelists to either agree with or disagree with. Secretary General Ban Ki-moon observed in 2011 that transitional justice initiatives promote accountability, reinforce respect for human rights, and are critical to fostering the strong levels of civic trust required to bolster rule of law reform, economic development, and democratic governance. So the Secretary General's remarks imply to us that transitional justice and the rule of law are complementary, at least in their goals. And I'd like to ask each of our panelists to say if they agree with that. Perhaps we can start on this with Andrew.
Thanks, Jim. It's good to be back, caveat and all. To answer the question, I would say yes, but it's a qualified yes. I do believe rule of law and transitional justice are complementary. Both transitional justice and rule of law are forced to deal with a variety of injustices, if you will, in so-called transitional contexts, whether we're moving from the authoritarian to some form of democratic rule or from violence and conflict to peace and stability. And I'm talking about things like the mass atrocity crimes, the violations of physical security, arbitrary detention, torture, and SGBV. And we add to that the housing, land, and property rights, and also widespread discrimination and exclusion of whole groups, on top of the breakdown in law and order and the rise of crime and corruption. And ultimately, I think these pose significant challenges for both. And how I think they're complementary is that they both have this shared orientation towards promoting justice and also combating and reforming the structures and the cultures that entrench impunity over time. So justice for me is the organizing principle and the shared goal of both. But as I think we know, there are various conceptions of justice and there are various approaches to achieving justice. And this is where I see the divergence between rule of law and transitional justice as areas of practice. Here I'll be somewhat conceptual, because on the one hand we have retributive justice, and that's the criminal accountability. That's the blame, the guilt, and the punishment of perpetrators by the state for violation of a state norm or state law. And in many ways, we see rule of law programs in the post-conflict and post-authoritarian contexts really oriented towards this retributive form of justice. And we just came from the panel on criminal justice law reform, and I think you could hear a lot of that. It's about police, prosecutors, and corrections. But then we know that justice is more than just criminal justice and law and order. It's also about the bad guys and getting the perpetrators and all that, but it's also about the victims and society as a whole, and that's where restorative forms of justice and transitional justice really begin to enter into the mix. These are more victim-oriented in that they really seek to acknowledge and deal with the injury and the suffering of individuals and communities that are victims of violence, to begin thinking about that less as a crime or violation against the state and more about a violation against the individual and the community, and then seeking of ways of bringing both the individual and the community into the justice response and the remedy that goes with it. So in TJ, or transitional justice, that's where at least I see the truth-seeking, the truth and reconciliation, and also the reparations coming into the mix, as well as the criminal accountability, and really complementing the criminal accountability. So just a couple quick points. I think we're supposed to be shorter here. The way I do see that they're complementary, at least from the transitional justice perspective, is that to the extent a government is committed to the process and the norms to deal with past crimes, they are putting in place a foundation for future rule of law. And this is the so-called signaling function that transitional justice can do. The government is actually signaling to society that it's not business as usual, that they will bind themselves by the law, and that they will actually hold people to account. And that, I think, goes to the rule of law culture. And then just they are complementary, I would just say. And then for the rule of law side, I think the rule of law can actually build up a lot of the institutions, deal with politicized and very weak justice institutions that are necessary for a transitional justice process to move forward.
Thank you, Andrew. Betsy?
I'll jump in, and I think I agree with just about everything that Andrew has said, and maybe I'll elaborate and add some additional points about ways in which transitional justice and rule of law are either complementary or maybe conflicting in some circumstances. I think we can all agree at a very broad and abstract level with the Secretary General's comments, but that really doesn't get us very far because it is so abstract. It's as abstract as the concept of transitional justice and rule of law. And as Andrew elaborated, it really depends on what those concepts mean in practice. It also depends on very fact-specific contexts in particular conflict or post-conflict transitional justice contexts. It also depends, I think, importantly, on the time horizon that one has in thinking about transitional justice and rule of law. There are instances in which, if you have a very short time horizon, transitional justice can be very disruptive of rule of law. It can alienate the local elites that you need to engage in rule of law reform. On the other hand, in other circumstances, transitional justice can get some bad actors out of the way and make space for rule of law. So again, very context specific, very time frame specific. Over the long term, I think in most cases it's pretty clear that some form of transitional justice is essential for rule of law, even if it might be disruptive in the short term or there might be difficult sequencing issues in the shorter term. So definitions matter, time horizons matter. I think in practice there are also very significant challenges that we face in taking advantages of the synergies between rule of law and transitional justice. And there are many, but I'll just flag one that won't surprise you, coming from the Executive Director of the American Society of International Law. I think there are different legal frameworks at play often in rule of law promotion and transitional justice, and particularly international justice, that international justice tends to be conceived of in terms of international law, implementation of international norms, whereas rule of law development assistance is very much focused on domestic law, domestic capacity building, domestic institutions. And that means that sometimes the programming on transitional justice versus rule of law can be at odds, or just people talking past each other, or missing opportunities for synergies. So those are just a few notes about some of the difficulties in this context, and we can elaborate as we get going.
Olivier?
Well, thank you, Andrew and Betsy, for your very thoughtful points. But I think I'll say that, especially in post-conflict situation, and I'm placing myself strictly on a practical viewpoint, is that transitional justice and the rule of law are all part of an intervention that comes in a moment that the states or the people are needs something either to restore the dignity or the state to restore its authority. And on that particular angle, I think it's quite difficult to make the distinction between the complementarity or not complementarity. I'll say that they are all part of the same intervention, a post-conflict intervention that needs a little bit of different things. And transitional justice, if you look at it in a way, is an opportunity to highlight the necessary rule of law reforms that need to be implemented. And at the same time, you consider maybe the rule of law as a way to actually strengthen or to give some kind of credibility or some kind of rigor to transitional justice initiatives. And if I just have to take an example, for an example, if you want to talk about all the processes of establishing the truth on atrocity that have taken place, and if you want to do that through Truth Commission, for an example, you need to ensure that there is a minimum of rule of law in the Truth Commission. So you need to establish that there is a minimum of procedural fairness in how the Truth Commission go about its business. Not going to let the Truth Commission completely work on people's rights or people's administrative rights, people's presumption of innocence because you want to establish the truth. So you have to utilize rule of law or principle to actually make sure that the transitional justice process is fair. And if you are looking at something that is very dear to people in post-conflict situations, especially victims, if you look at reparations, for an example, you can imagine that reparations can be rendered through, especially the judicial reparations. You need to have rule of law principles in the functioning of the jurisdictions or the courts to be able to pass decisions on reparations and have those decisions implemented. So I think it's all about how and when you make the intervention, but you realize that most of the time in post-conflict situations, those interventions are not necessarily done in a very coherent way, and then you tend to ask the question if there is complementarity or not. And because if there is actually ample time to reflect on how to lay the foundations of the restoration of the rule of law or the restoration of state authority or the restoration of the confidence between the people and their institutions, you actually consider the two as a very interconnected intervention.